Get ready for the dictation. Start. Heard counsels for the petitioner and the respondents state, while posted as clerk in the office of the District Superintendent of Education, the petitioner was made an accused in a trap case for the allegation of accepting bribe of rupees 10,000. Pursuant thereto, a charge memo was also issued to the petitioner on 14/8/2010. Petitioner submitted his reply to the same. The inquiry officer submitted his inquiry report dated 1/2/2011, wherein it was expressed that it was not possible to record any findings conclusively with respect to charge numbers 2, 3 and 4. However, with respect to charge number 1, it has been mentioned that the charges were not proved. Suspension of the petitioner was also revoked. The said findings of the inquiry officer were accepted by the disciplinary authority, which is evident from the office order dated 4/2011 issued by the disciplinary authority. It appears that as a matter of policy, so as to penalize corrupt officials, some decisions were communicated to the disciplinary authority again and pursuant thereto by letter dated 23/1/2014. All the district superintendents of education were directed to expedite the proceedings which were pending before them and to submit an inquiry report within a week. The said instruction was also with respect to the petitioner as would be evident from the list appended to the said order. Pursuant thereto, it appears that the petitioner was again placed under suspension by Annexure 7, which is letter dated 3/2/2014, whereby the proceedings were directed to be concluded on the basis of a charge memo. Pursuant thereto, the inquiry was concluded. The report of the inquiry officer is dated 8/3/2011. The findings of the inquiry officer is as follows. From perusal of the inquiry report, it is quite obvious that again the inquiry officer had retreated the findings recorded in the first inquiry report dated 1/2/2011 to the extent that during pendency of the criminal proceedings, it was not proper to record any conclusive findings in respect of the petitioner. The last sentence merely states that in respect of proved matters, the conduct of the delinquent would be considered contrary to the rules. The last sentence of inquiry report thus qualifies the first part of the order, wherein it is said that till such time the proceedings in the criminal case are not concluded, it is not proper/possible to record conclusive findings in respect of the petitioner. On the basis of such inquiry report and in respect thereof, the disciplinary authority, wide letter dated 19/3/2014, has called for the petitioner's comments. The petitioners submitted detailed reply to the second show cause. Again, the delinquent has denied the charges and highlighted the various procedural irregularities in conducting of the proceedings, including the total lack of evidence. Without going into the details of the second show cause, this court finds that it is specifically recorded by the inquiry officer in his report dated 8/3/2011 that during pendency of the criminal proceedings, it is not possible to record conclusive findings with respect to the petitioner. However, in respect of proved matters, the conduct of the delinquent would be considered contrary to the rules. Such findings of the inquiry officer are general and not specific to the petitioner and does not support the petitioner's guilt on any charge whatsoever. However, the disciplinary authority has called for a second show cause from the petitioner without even differing with the findings of the inquiry officer and has drawn an order of punishment dated 12/4/2014 against the petitioner, which is Annexure 1 of the writ petition. From perusal of the same, it is obvious that other than a pre-trap memorandum and post-trap memorandum, no evidence whatsoever has been considered so as to record the findings of guilt against the petitioner. The submissions of the State Council that the findings of the inquiry officer is against the petitioner is not acceptable. At best, the findings of the inquiry officer would be a general observation. Even if the same is accepted, then such vague and general observations cannot form the basis of inflicting the most severe punishment of dismissal of service of a delinquent. Such harsh consequences can only be inflicted upon the petitioner if there is a clear and definite findings holding the charges proved with reference to relevant and cogent material adduced in an inquiry conducted in accordance with law. This is not the case here. Stop.